and I'm delighted to introduce my panel for this conversation. I'll start with Dr. Robert Millard, who is Director of the Cambridge Strategy Group, which he founded in 2012, following a period as in-house business strategist at Linklaters in London. And Robert did some PhD research, which we're going to dive into in a bit, that analysed the drivers of success in mergers, 73 different UK and US large law firm mergers. I don't think between UK and US, but they could have been UK or US
involving
mergers.
one or
the other. Between 2002 and 2017. And so we'll try to draw out whether some of the findings from that are sort of relevant to what we're currently seeing as well. We also have Katie Cramond-Hill, who's Director of Business Development at McDermott, Will and Schulte. That's a recent merger from last year, I believe.
Yeah, summer.
So we'll talk to you about some of the drivers for that combination and some of the challenges. And we also have Tina Williams, partner at McCarthy Denning. And you were, Tina, for many years before that, senior partner and chair at Fox Williams. And your specialism is law firm partnerships and all the various moves that dealing with that might involve, which includes, of course, mergers and other types of combinations, as well as regulation and partner and team moves. And you're also an active participant in the Association of Law Firm Merger Advisors. So, start with you, if I may, Robert, to give us a little bit more on what the research that you carried out in that period. What did you learn about the reasons that firms merge and whether those were the right reasons during that period?
Okay, thank you. Just as an aside before we start, if anybody's planning to do a PhD, come and speak to me afterwards and I'll disabuse you of the notion. It was a 7-year slog. Very glad it's finished, and I think that the material, well, I've been told that the material I produced is unique and valuable. So I hope that if you are thinking about a merger, you are welcome to a copy of my thesis. You can find it at the University of Glasgow Library. There's no charge. So what started all this was back in 2010, just before I joined Linklaters, I advised Denton Wild Sapt on their merger with Sonnenschein. And that was a fascinating exercise, and it really got me intrigued about how one combines businesses like big law firms. And I've advised on a couple since then, and then I guess it must have been about 10 years ago now, I did some research just looking at the financial performance of firms before they'd merged and then for 5 years after they merged. And I noticed that there was usually a dip, but back to kind of pre-merger figures by 2 years afterwards, and then very often a genteel decline, followed sometimes by another merger. So I thought, after many different ways of thinking about how I might structure a research project, to land on what kind of conditions can you observe before a merger. So putting myself in the shoes of a managing partner, thinking, I think we should merge. Which firms should we look at? What should we do? Given the information out there in the public domain, which conditions, which combinations of conditions are consistent with a successful outcome, which meant that I had to define what success meant to begin with, because nobody did that. All the literature is on on stock market metrics, in merger and acquisition research. It's on how much the share price moved within minutes of the announcement, that kind of thing, which of course is completely irrelevant to us. So I developed a rubric that was two years out. Was the profitability better than it was before? Had revenues grown more than the rate of inflation? Was the combined firm ranked in more areas in Chambers than they were before? And had their average score improved? And if all of those were true, then it was wholly successful. And if all of them were false, then it was wholly unsuccessful. And the first punchline is that 75% of those were successful. Now, we're talking about 75% of mergers that actually went through the whole negotiation process, due diligence, and execution. So it excludes any, Tina uses the term, if I may steal it, successful failures. It excludes all of those. And on that basis, I found that there was one condition that was consistently successful, and that was about strategy, which was music to my ears, given that's my field. And that was a multi-dimensional strategy. So I looked at scale, I looked at doubling down on existing strengths, I looked at going into new strengths, I looked at some kind of efficiency play, which I linked to profitability, and I looked at entering new markets. And if the merger delivered all of that, that was consistently successful. If it only delivered one or two, it didn't mean it was going to be unsuccessful, it just meant it was not consistently successful. So that is the first point. The second point is a multi-dimensional strategy, consistently successful. The second one was where a firm that was in genteel decline combined with a firm that was on the up. So a rescue, if you like. I call them white knight mergers. Those were consistently successful. The third was where the firms were very similar to each other. And that's also supported by the merger literature and common sense. They tended to be successful, consistently successful. And then there was one last one, which was very rare. There were only 2 cases in the 73, and that was what I called a leapfrog merger, where both firms had been doing okay. They'd merged anyway for strategic acceleration, I called the reason. But if I may, there was one last point I'd like to make, and that is that in the early stages of the study, I went through over 400 pieces of literature, articles, announcements, white papers, newspapers, about why firms merge, why they say they merge, and what practitioners, what we say drives a successful merger. Over 400. Only 1% of those, so 4 out of the 400, talked about innovation and technology. I think today that figure would be different.
Different today, yes, yes. And Tina, do you see this? You see, looking now at the landscape that we're in now, do you see similar dynamics at play when it comes to why firms are merging and why they should be?
I think the reasons that firms are merging are exactly what Robert has said. But in my view, there's a reason why the words mergers and acquisitions are often rolled together into the same little phrase and abbreviated to M&A, and that's that real mergers and in specifically mergers of firms of similar sizes are quite a rarity, and what is often presented as a merger is in fact an acquisition. And the way I define a successful merger is where the strategic objectives of both sides are met. And I don't think that's necessarily a function of size, two firms of similar size coming together. I think it's more a function of what do you want? What do you want? Can we achieve both parties' requirements? To give a concrete example, if you had a large firm which wanted to set up a new practice area, and because clients were saying, we want you to do this for us, but didn't have the expertise, and you had a significantly smaller firm with expertise in that field, but not the resources to develop that in any meaningful way, putting those two firms together could actually, in merger terms, be a match made in heaven. So I think, as Robert said, it's not a function of size, although that may help. It's a function of the strategy. How can that be achieved for both firms and not just one of them?
Okay, that's interesting. And so the recent, we've seen a number of mergers recently over the last year or two at the large end of the market, and then in the mid-market, towards the smaller end. Is each one of those mergers then following on its own strategy, or do you think there's something, and this is to anybody really, or do you think there are forces in the market at the moment that are driving firms to consider it as a priority?
Well, I think there's a lot of insecurity in the market at the moment, that firms are sitting there seeing all these mergers going on and thinking, gosh, should we be doing the same thing? And I think we're going to come on later on to talk about what might the alternatives be to that strategy. But in terms of successful mergers, which are the only mergers worth doing, I think one of the metrics that one can judge a successful merger by is how many people that both firms want to keep and have driven the merger are actually with the combined firm 1 or 2 years after it and are good ambassadors for the firm. It's the attrition rate. And if there is a high attrition rate, that indicates to me that the combined firm has perhaps not been able to create the environment where, or the strategy where people can identify with a vision or can feel comfortable about their role in it. And therefore, I think that's as important as the financials, as increasing the bottom line.
Yeah, thank you. And we absolutely will come on to talk about that some more. Katie, if I come to you now, so you're an example of a merger, your firm. What were the core strategic drivers then for you? Do those match what we've been talking about here?
Definitely.
And also, how did you measure, or how would you measure the success as well?
So much of what Tina's saying is resonating with me. So just as a bit of a recap, McDermott, Will and Emery merged with Schulte, Zoth, Roth and Zabel last summer. Our chairman described it as, I think, the fastest merger that's ever happened. It happened in 3 months. We became a $3 billion law firm. I kind of heard about it in May time, and the paperwork was signed in August. So as a BD professional, obviously I'm very much focused on the client side. I will say that I am based in London, so I come at it, my perspective is very much from the kind of European London lens. But what I saw that I think is really interesting is McDermott very much wanted to position itself, and it's kind of back to that kind of sector density, speciality in the private capital space. And Schulte were very much seen as the leader in that. So for us, it was a great alignment in terms of the strategic priorities for them to join. So they kind of shared in that vision. So I think the sector part was a key thing. I think also kind of what Robert was saying, the access to markets. I think to see success and new entry into a market, you're looking at kind of 5 to 10 years. This kind of gave some of the Schulte clients that had never been able to work with Schulte in Germany and Paris. And from my perspective, I'd never been so busy because a lot of the Schulte partners were so excited to finally have access to European jurisdictions. So it was fantastic from my perspective. And then I think what I've understand from the Schulte side is that they were really investing in McDermott had put an incredible amount into technology, into knowledge management, into a kind of BD engine, they like to call it. So they were getting a lot of those kind of functions which they hadn't really had access to before. So I think from my perspective, those were the kind of 3 drivers. And then in terms of the kind of, again, we spoke about this on our prep call, but I think it's the hard work comes after the ink's dry, and it's that behavioural, cultural change. I think, if I'm being honest, it happened incredibly quickly for McDermott, and I think some of the lessons that I kind of learned was, I think, some of the cultural pieces. It could have been socialised. It would have been nice to have had kind of a 6-month lead time. I think 3 months was quite quick. We also had to go through a brand refresh as well. So it was kind of getting everyone along with the identity and feeling part of one firm. And I think also we spent a lot of time ensuring that partners were trained and lawyers were trained on how to sell the new firm and feel comfortable selling that to clients, and being able to kind of go out to market with a strong market narrative.
What's practically involved in that? The sort of the branding consistency point, and then also the point about selling the new vision to clients and considering client, who in the different parts of the firm has access to which clients, for example, and collaboration around that when two businesses come together?
I think, we were incredibly lucky that both firms were very transparent and open, and I think that kind of goes back to the cultural piece in terms of that's the only way it's going to be successful. So we had access to the top 100 clients from Schulte. We obviously kind of were mapping that in terms of where the crossover was, where we thought there was opportunity, where other firms were already taking that work in jurisdictions that McDermott had an office, so we could really proactively go out to clients. I kind of, after listening to the GC panel, I'm a bit scared to say the cross-sell word, but that kind of is my business. But thoughtful cross-selling, shall we say. We wanted to do that not as a mandate, but that was really around familiarity and ensuring that we just did so many meetings and trainings and making sure that there was so much integration, and obviously all these amazing things that we can do now where you don't have to be in person, that we've learned obviously over the last couple of years. So it's been, it was a lot of time and effort, and just ensuring that everyone felt really comfortable and knew the experts across both firms.
Excellent, thank you. So coming to the point about merging cultures, if that's the right way of putting it, because I suppose, do the cultures actually merge, or is one of the cultures more powerful than the other, and the other party needs to adapt its culture to the other law firms? What do you think to that, Robert?
I think it depends on scale. I mean, Tina spoke about mergers versus acquisitions. If you're assimilating a very small firm into a very large firm, then you're joining a new club, fit in with the new club's rules. I think it gets really interesting when you have parity, power parity between the two firms, because then a lot more argument ensues about how things need to be done in the combined firm. And it's interesting, I don't like invoking the scholarly literature too much because people then think I'm an academic. I'm not a practitioner. But there's very little research done on what they call cultural fusion. So taking two different mergers and then fusing them into one different one. It's almost nothing has been done on that. And perhaps that's why there's so few peer-to-peer mergers, because it's so darn difficult. There are also aspects of culture that drive performance and that are necessary to be able to execute the strategy you set for the new firm. So in some aspects, there are rights and wrongs to culture. In other aspects, it's kind of Myers-Briggs for law firms, where it doesn't really matter, except that people will fight about things that don't matter. So then you have to have a discussion about what color the paperclip should be, so you don't have an argument about that.
I also think the name, sorry, just really quickly jump in there. I think the name is also really important. I think if you look at kind of A&O Sherman, McDermott, Will and Schulte, we were very conscious of the brand power that the Schulte had. So I think naming is often a really important part of that kind of identity
articulating
as well.
Yeah. Tina, what do you think? What sort of obstacles crop up when it comes to the cultural question?
Well, what I've found very curious about many merger negotiations is that management teams often think culture is such an all-encompassing thing. It affects every aspect of the life of a law firm. It's too big to actually deal with pre-merger. Let's put it to one side and work on it once the merger has taken place. And I think there's a certain amount of logic in that. But I think I certainly have not met the law firm that's got culture 100% right. I think that a mindset coming to merger negotiations that both firms can learn from each other. But I also think that it's absolutely critical for certain aspects of a culture to be discussed pre-merger and to be determined pre-merger. And those aspects are really, what is the mutual vision going to be going forward? And what are the critical factors? How does the firm need to be in order for that vision to be realised? And the reason I think that is so important is that it's a real opportunity. If that vision can be formulated in a great way and can be well communicated, it can be inspirational for the people in both firms, and can actually kickstart a merger. If you can get people behind that vision before the merger takes place, yes, there's a lot of flesh to be put on the bones afterwards, but I think it's absolutely key, because if there is not a unity of vision going forward, then it's not going to be a successful merger.
Is it an opportunity for a new vision, for them to refresh, values, for example? And sort of-
Absolutely, it's a tremendous opportunity. And as I say, both firms will have things that each can take from the other, but it's sometimes the case that neither firm has got it right, and something different is needed because the business is going into a whole new phase as well, and different management styles, different people issues are going to arise in that new business.
And what about where, some of the people involved in the merger or the potential merger aren't as keen as others? How do you deal with sort of conflict arising, potential conflict or uncertainty or whatever you might want to call it, or scepticism?
Well, I think you've put your finger on why it's important to actually articulate that vision beforehand, so you can identify the people or the groups within the two organisations that will not be able to subscribe to that new vision. And often pre-merger involves saying goodbye to some people. And that's tough, but it's much better to have to say goodbye at that point than to have everybody come in and then have terrorists within the organisation trying to sabotage a strategy that they simply don't subscribe to.
Robert, when you mentioned at the very start that technology, when you were doing your research, wasn't often mentioned as a driving force for this, and that you thought it might be now. But do you think now that would be a potential new vision that you could articulate to the people who are going to be involved?
I don't think
commitment to it. Yeah.
I think it's going to become one. I don't think it is yet. I don't think it's an overt theme on top of the others, but I think it's underlying. And the reason for that is if we look at the firms that are in decline, and the data is all there in Companies House. You can pull it and look at every firm in this room, except Slaughters. But there are many firms that the raw truth is that their revenues are flatlining at best, and their costs are rising, and there's going to come a point when the two cross. And so they would be thinking about whether a merger is an option to solve that problem. And AI and technology form an integral part of that equation right now. Merger waves, so there's such a thing as a merger wave, not just in law firms, generally in the market. They tend to follow three things, not during. One is regulatory shocks, one is economic shocks, and one is technological shocks. And we're having two of those three right now in the legal sector. So there are going to be more firms that find that there's an iceberg out there, and the steering wheel doesn't just work quite enough on its own, and should we be linking up with another firm? So in that context, I think that AI is absolutely going to be a key issue. And it's also, from the point of view of a firm that's on the acquirer side, everybody's having to transform their work processes, reinvent new work processes ideally, and it's extremely hard. I don't think there's anybody in the room here would say it's easy. So if you're on the side of a firm that is looking at taking on a firm that is perhaps under pressure, you need to look very carefully at their mindset, their ability to transform, at least to the standard that you are. I would almost say that if you have a binary choice right now to merge or to get on top of AI, don't merge. Focus on AI.
What do you think to that, Tina? Would you agree with that?
I think it takes great courage to walk away from merger discussions, particularly once the press has got hold of the story and expectations of people within the organisations have been built, and expectations of clients too. But I would say roughly in 2/3 of the merger discussions I have witnessed, people have had the courage to walk away, and that's what Robert referred to earlier as the successful failures, because it was obvious in virtually all of those cases that it was absolutely the right thing to do to walk away. Merging is a very high-risk activity, and due diligence is absolutely key in all aspects of law firms, and that includes due diligence into cultures, because that's what can make or break.
Okay, yeah. Are there other alternatives that you can think of for firms? So we talked about investment in AI potentially instead, or committing more to that. What else for firms that feel that they have to do something?
Yeah, I think there are a lot of firms in the mid-size, mid-market at the moment that are beginning to feel rather uncomfortable. And I think one of the options for them to look at is, should we actually be going for scale or staying as we are and just growing organically, in which case we might be trying to be all things to all men and not really achieving any competitive edge? Or should we be focusing on a particular or a group of particular practice areas and become the go-to firm for those practice areas? In other words, should we become bigger or should we focus? And I think both of those strategies can be successful. But I've just got a feeling that many firms in the mid-market at the moment would be better thinking about focusing rather than just trying to get bigger.
And you were talking to me earlier about one of the things that you're seeing is an increase in talent moves, lateral hires. Did that follow that?
I think that's possibly driven by different factors, but certainly people like to feel that they're in an organisation doing something which is held in value. And so a firm without focus, where you've got real specialists who are at the top of their game, may feel, actually, this is not the right platform for me. I'd be better off going somewhere more focused. So I think there is a link. I don't think it's the only driver. I think money is one of the big drivers in that.
Katie, you mentioned that in the case of McDermott Will and Schulte's merger, you thought that technology was one of the plays. Can you tell us a little bit more about what that looked like, what that looks like now?
Yes.
What has it enabled you to do for the firm?
I'm a huge fan, I probably shouldn't say this to some people in the room, of Salesforce. As a BD professional, it's just absolutely changed my life. I think it's fantastic. And so Schulte just didn't have, they didn't really have much of a BD function, and they hadn't had exposure to what I would call, I think McDermott has a best-in-class business development function. And so they were able to kind of integrate into our CRM system, Salesforce. They were able to see how effectively using CRM can really connect the dots and help you drive growth for your clients. And I think we're a very data-driven firm, and we've been talking a lot today about ensuring your own data is cleansed and it is in good shape, and I think that is something that McDermott does incredibly well. So I think, and also we've invested heavily on the tech side, so kind of using a lot of AI tools, both on the kind of business services side and obviously on the legal side as well. So I think that was attractive to the Schulte to kind of merge with McDermott.
Thank you. Any questions from the audience at all? Have we got a microphone? Yes, a question down the front here. Thank you.
Say your name.
Hi, it's Martin Palmer. I'm from Clark Wilmot. Tina, I was really interested in one of your opening remarks about the often the use of merger and acquisition to mean the same thing when in reality they're very different. Why are law firms, I don't come from a legal background. I was really surprised when I started to see that. Why does that persist, given that they really are very different things?
Well, I think that's a very interesting question, but I think that firms which ostensibly are very similar, they're of similar size, they're in similar practice areas, and together 2 and 2 might make 5, I think they can be incredibly different internally, and the way things work and the way success is achieved. And I think it's that intangible factor which makes mergers so difficult to pull off, and which is why perhaps I've put too much emphasis, but I've put a lot of emphasis this afternoon on culture and the importance of culture and getting those to be compatible or to move forward together rather than trying to dress something up as a merger which is not. There is usually a dominant firm, and one's got to make sure that is the dominant firm, is that going to be the dominant culture, or is something else more appropriate going to evolve from that?
Thank you.
I think there's also just a very practical reason, and that is that, strictly speaking, an acquisition means acquiring for consideration, whereas a merger is putting 2 organizations together, creating a new organization, and it's all worked out with equity. So strictly speaking, partnerships don't acquire partnerships. They merge. And so it's just semantics, perhaps. But the semantics that tend to hide what the points that Tina made that are so important about power asymmetry.
Yeah, I think there might be beginning to be a bit of a change in that with the advent of PE into the legal marketplace, because traditionally law firms have not been bought and sold, but now they are. And so, there are acquisitions in that sense. But I think there are acquisitions in more than the financial sense. There are acquisitions of businesses which can be moulded into the bigger mould of the dominant firm.
Agreed.
I think also from a leadership perspective, I was very fortunate that both the Legacy McDermott and Legacy Schulte chairmen were both very aligned, and I think that really came across to everyone internally. So I felt very kind of secure in the fact that this was a joint decision, very much benefited both sides, and I think that really helps the cultural piece, so everyone feels like we're all on, swimming in the same direction and on the same journey. So I think ensuring that the leaders are aligned is really important as well.
Thank you. Time for probably 1 or 2 more questions, if anyone has one. Anything?
Don't be afraid of the mic.
No, definitely don't be afraid. Be afraid to merge, but not with the microphone. What about the? You brought up private equity, and we're going to have a longer conversation about that with the next panel. What impact do you think that is going to make to what I don't know whether to call it a trend, but to the sort of dynamics that we're seeing that we've been discussing? Robert?
I've always had a jaundiced view of external investment in law firms, particularly partnerships, and I'll very briefly explain why. Many years ago, I advised a firm that had sold itself to a merchant bank, and I was brought in with EY to determine fair value for the firm 4 years after they had 5-year golden handcuffs, and this was year 4. And the partners have said, just so you know, we're out of here at year 5 because you're not paying us enough anymore and we can't attract talent, and all sorts of tales of woe have been externally owned. And after the Legal Services Act was promulgated here in 2007, was it? I would ask groups like you, why, if you were to take in a lot of money, pick a figure, doesn't matter how much, how would you create enough profit to be able to pay your partners what they need to be paid to stop them going across the road, and also satisfy the ROI needs of this entity that has put in a lot of money? And people would come up with golden hellos and open new offices and growth this, growth that. That's revenue, that's not profit. How are you going to increase your profit to be able to pay what the private equity, in this case, house expects? And then never mind getting on to the discussion about exits. So I don't know. I have yet to be convinced. I can see it in very specific cases. I can understand DWF's model. That's fine. That's different. And I can understand it with very small firms, rolling them up perhaps. But I think it's great for the law firm, but wow, I see red flags for PE houses. And it's very little investment so far. If you look at the total amount of investment into private equity in the UK, and what percentage of that is law firms, it's vanishing. It's rounding to zero. So I think that there's some private equity houses that are experimenting. We'll see how that goes. But that's my opinion. I might be completely wrong.
Do you have a view on that, Tina?
Well, I think that's absolutely spot on. And I have always traditionally thought that private equity is a very expensive form of financing. And the exit point is very well made. What is going to happen in 5 years' time to these firms which have been funded by private equity when they're desperately looking for an exit? So I'm not a great fan, I have to say.
Okay. Well, that's interesting.
I
We'll see
better
what
not attend
happens
this
next.
afternoon's session.
Well, it's immediately afterwards, but that's right. What happens to firms that don't do any of these things that we've talked about? Do they have to do one or the other, given where the market is at the moment, given the competitive pressure? I don't just mean private equity or merging. I mean, you pointed to technology as also an alternative. What do you think?
Well, it's very difficult to close a law firm down in this country. Tina can explain. She's a lawyer. I'm not. 15-year liability tail, so it's really difficult for the partners. So it's really difficult. But I was talking to a general counsel a couple of weeks back, and I said to her, will there be what does she think? Will there be an inflection point where law firms suddenly have an epiphany and they adopt AI? And she said, no, Robert, it's far simpler than that. The phone will just stop ringing. And what happens when a firm actually goes insolvent, given the 15-year liability tail? I don't quite know.
I think doing nothing is not an option. The market is moving so rapidly that I think doing nothing will result in decline, and ultimately, in worst-case scenarios, distress. And Robert's alerted us to the fact that law firms are not allowed just to close down. They have to buy very expensive run-off indemnity cover. And as a firm does move back in the market and is in decline, you tend to find that the people who have other options will make a beeline for the door, leaving very few people left to carry the can. So whatever option is chosen, whatever the right strategy is, and it may well not be merger, every management team should be thinking about that now. What should our strategy be in our particular special circumstances?
Okay, thank you very much. I hope we haven't scared everybody, but thank you very much to Robert and to Tina, and indeed to Katie. Thank you for joining me for this panel.
Thank you.